Guess I really don't have to look both ways, do I? I'm always the last one to get seated. Anyway, please be seated. First case on our afternoon docket is styled Vigil v. People. We've set this one for 1 hour. Both counsel look present. Mr. Cox, why don't you go ahead and start?
Good afternoon. May it please the court. My name is Brian Cox, registration number 50258, and I represent Mr. Vigil. The court granted certiorari on 3 very important issues in this case, and so recognizing my limited time, I invite the court at any point to interrupt me and focus me on the areas where you have the most questions. Beginning with the first issue, which was a defense challenge for cause to juror CA. That juror expressed doubt about his ability to render a fair and impartial verdict. The only time that he was questioned about his ability to render a fair and impartial verdict was by defense counsel. Defense counsel asked if that would be difficult, and he said, "I can't say, I really can't. I'd like to say no, but I don't know." Defense counsel followed up, "Are you saying you can render an impartial verdict or not?" The juror responded, "It's something that sits there. I know the people, I really do. I don't know the defendant." The court's only follow-up question was about that juror's ability to treat the alleged victim, or really the victim's testimony, the same as anyone else's. That question really doesn't get at the ability to render a fair and impartial verdict. So what we have here is a situation where the juror expressed doubt and was never rehabilitated on that question. Under this court's precedence, it is clear that in that situation, the juror needs to be dismissed for cause.
Let me accept your invitation and jump right in. So Carrillo, I know that you explained that you thought there was more rehabilitation that went on in the Carrillo case than is evident here. Walk me through that, because Carrillo seems, in a sense, similarly questionable in terms of whether or not that person should have been allowed to sit. We said that was okay. Why shouldn't this be too?
So the key distinction is that in Carrillo, the court specifically asked if the juror could render a verdict based solely on the evidence presented, and the juror said yes. That simply never happened here. So that makes Carrillo a completely different world than the one that we're in this case, where there simply was no rehabilitation on that question.
But was that question asked generally? I seem to recall that that question was, there were 3 different areas of concern in Carrillo, and I don't know that that question was ever posed with respect to the relationship that the prospective juror had with the father of the victim in Carrillo. So I wondered whether they aren't more similarly situated.
It's true that there were 3 areas of concern in Carrillo. Nonetheless, I think that by the trial court asking that question and getting an affirmative answer, that really encompassed all of it. And also the 3rd area of concern was an employment relationship. I don't believe that in Carrillo it was quite as clear that there was also sort of a social friendship aspect to it like there is here. But really the core distinction is that question, can you render a fair and impartial verdict? And if you look at this case and you look at the voir dires of other jurors who were challenged, you'll see that the court did ask other jurors if they could render a fair and impartial verdict, and received either a yes or a no answer to that question, but chose not to with this juror. And I think that that decision not to question further on that really is dispositive.
Thank you.
I would also just like to briefly point out how the Court of Appeals and also the state in its answer brief misinterpreted this court's decision in Lefebvre. That decision where the court used a phrase, I forget the exact phrase, but something about clear, certain bias. That was in reference to when the court could dismiss a juror without allowing any questioning, simply dismissing the juror based on the questionnaire alone. So the standard for that is very high, that the juror has to be clearly very biased and not susceptible to rehabilitation. That's not the standard here when the challenge arises out of answers that happen in voir dire. And so Lefebvre is not relevant precedent at all.
And so what do you think what's the difference between the two standards?
Well, I think that the standard is best spelled out in Rousseau, where Rousseau talks about if the prospective juror says something that illustrates bias, then they should be dismissed unless it becomes clear through rehabilitation that those statements were a result of mistake or confusion, and the trial court is confident that this person can render a fair and impartial verdict. Whereas Lefebvre really just addresses if someone is on their face so obviously biased that it's not even worth trying to rehabilitate them.
I know, are you finished?
Please.
I know it wasn't explicitly a cert question, but I was surprised to see that there's really no discussion other than maybe the citation to Morrison about what we should do if we agree with you about CA. Does it necessarily follow that it's per se reversible error? And if so, isn't that almost kind of like a return to McCrander?
No, that is not a return of McCrander, and yes, it is automatic reversal. The U.S. Supreme Court decision in Martinez-Salazar makes clear that when a biased or incompetent juror actually participates in the verdict, then that is structural error, not amenable to any sort of harmless error analysis. And that was not addressed in the briefing because that is settled law, that no division of the Court of Appeals has suggested otherwise. If there are no other questions on the first issue, I'll move to the second. So the second issue also relates to a challenge for cause to a juror, and that was the prosecution's challenge to juror DK. The Court of Appeals declined to reach the merits of that challenge because it held that the error was necessarily harmless so long as some other biased or incompetent juror did not sit. That standard is essentially a rule of automatic affirmance, and that standard is not what this court's decision in Novotny called for. The decision in Novotny called for essentially harmless error analysis. So under Novotny, when an error is made that affects the party's allotment of peremptories, then that is a trial error that is susceptible to harmless error analysis. Novotny also made clear, though, that the purpose of that opinion was not to say that all such errors are necessarily harmless, simply that they are open to harmless error analysis. The state's rule and the Court of Appeals rule does effectively mean that they are always harmless. Requiring some other biased juror to participate in the deliberation would be an error in its own right that would require automatic reversal under Morrison, and so there's no logical way to treat that as also being the harm test for a different error.
Isn't that actually what you're saying happened here? I mean, there was a juror on the jury who you say was biased.
There is, but there was no causal connection between the two errors.
So the rule that the Court of Appeals would apply is the defense has to be able to strike a juror, and then immediately after the next juror seated has to be biased?
I believe so. The Court of Appeals says that there is no harm unless a biased or incompetent juror sat as a result of the error. And presumably that would mean that the next person called up is biased or incompetent and ultimately ends up sitting. But any appellate advocate would simply raise that error in its own right, that a biased or incompetent juror sat.
Yeah, it wouldn't have to be the next person. I mean, the argument, it's what we have here on your position. CA wasn't the next person, but ultimately if you win argument one, then you get to say a biased juror sat.
Yes. However, the issue in argument two is that it should not require that some other biased juror sat.
So
it happens that in this case one did.
Yeah, understood. So you cited a number of cases that were interesting. Mason in particular is interesting to me. Articulate the rule you want us to adopt for how to assess prejudice. I find that to be the most difficult piece of this.
So first of all, I think it's worth stressing that under harmless error review, the burden is on the state. So it's really a matter of how can the state go about proving a lack of prejudice rather than
So what's
how
the
we would
standard
prove
we
it.
adopt?
So I think that, like all harmless error analysis, the court would look at the totality of the circumstances. So one factor that courts almost always consider for harmless error is the overall strength of the state's case. There was a Louisiana case that I cited in the briefing, I forget the name offhand, that did look at that and ultimately did reverse because the state's case was otherwise weak. I think in addition to that, you can look at the specific juror who was improperly excluded. That's the posture here is that we're talking about a juror who was improperly struck. It would be a little different if it was the other way around. But you would look at what that juror said in voir dire and how those statements might relate to the nature of the case. That's essentially what the Mason court did, was look at how that juror talked about racial dynamics and talked about bias within the legal system. And the court in Mason held that that was a relevant and helpful perspective that the defense should have been able to have on the jury. In its answer,
I'm sorry, to that point, it seems that that assessment of prejudice is getting at what difference might it have made had the juror who was excused actually participated, right?
That's correct.
But you would agree that you don't have a right to have a particular juror actually sit.
There is no Sixth Amendment right to have a particular juror sit, but there is a statutory right to have a jury that's constituted properly following the rules. And so in a particular case, that would include, in this case, having DK sit, because following the rules correctly, DK would have sat. And this case is noteworthy because it is 100% certain from the record that he would have. The prosecution had already exhausted its peremptories by the time DK was voir dired. So it is certain that that juror would have sat but for the error. So the question is not whether there's a right to a particular juror. The question is, once an error has been made, how did that affect the trial? And the way that it affected that trial is the exclusion of that juror. And so the court can look to how that juror might have influenced the deliberations.
But how do you know that? I mean, so the issue in Mason was an interesting one, but do you have to assess, that juror seemed to really understand the burden of proof, or let's take DK. Yes, you're innocent and proven guilty. There's two questions. What's the remedy? I mean, that you're asking for? Is it a remand for a hearing to see you prove prejudice? And then what evidence gets presented there? Does the trial defense lawyer testify, he was going to be a good juror for the defense. He was going to hold the prosecution, so I liked him. I mean, what's the standard?
So the remedy in this case would be reversal, because
for a new trial or
for a new trial, because under the facts here, I believe it is clear that it did influence the verdict. Certainly,
how? That's my question.
Well, using the factors that I laid out, the state's case was otherwise not very strong. There was an acquittal on all of the counts that did not rely on Sergeant Crown's testimony. DK expressed some level of skepticism about police officer testimony. There is inherently always in harmless error analysis some level of speculation, which is why the analysis is framed in terms of a reasonable probability of influencing the verdict. And so I think when you look at it in terms of that reasonable probability language, and you look at the state's case and you look at DK's statements in voir dire, particularly where it's certain that he otherwise would have sat on the jury, I think it is easy to conclude that there was a reasonable possibility that it affected the verdict.
And I'm sorry to keep pushing, I'm just having trouble envisioning what this looks like. So do you end up comparing DK to does the defense lawyer say, I wouldn't have struck this juror, this juror would have sat, not DK, and this is why DK would have been better? Or I said that backwards, but I think you understand. Are you going to compare jurors that DK would have been a better juror than the one who ultimately replaced him, or what?
So the juror that replaced DK in this case was TC, who was questioned immediately afterwards. I think the court could do that sort of comparative analysis. If you look at the Mason case, I don't think that kind of comparative analysis happened there. It was enough to simply show that this would have been a valuable juror to have on the jury. But certainly a comparative analysis could happen. I think that if the court did that in this case, TC's responses did not show that same level of commitment to the presumption of innocence or the prosecution's burden. And so I think that that analysis would favor Mr. Vigil if done in this case. I think it would vary in other procedural postures. For example, if the prosecution still had peremptories left, or in a case where it was an erroneously denied defense challenge instead of an erroneous prosecution challenge. But looking purely at the procedural posture here, it's very easy to see what the constitution of the jury would have been without the error. So there's no need for any further record on that.
And as a point of clarification, are you saying that the prosecution, by the time the prosecution made the challenge for cause to DK, had already exercised all of its peremptories?
So the jury selection method that the court used in this case was that voir dire was only done on the 13 jurors in the box. And then every time someone was dismissed, either for cause or pursuant to a peremptory, there would be a fresh voir dire done solely on the replacement juror. So both parties had exercised all of their peremptories. DK, actually a few jurors were called up and then all dismissed for cause. DK was called up, he was dismissed for cause, and then ultimately replaced by TC.
I take you back to, you said, because of our recent decisions, that the prosecution would bear the burden of proof. We might have said burden of persuasion. What do you take the burden of the prosecution having the burden of proof to mean?
Well, I think it means that any ambiguity or anything speculative about the analysis weighs in favor of reversal rather than in favor of affirmance, because it is ultimately the prosecution's burden to show, whether you use the term prove or persuade, the prosecution's burden to show that there was no reasonable probability that it influenced the verdict.
So would that turn out to be then, if we as the appellate court couldn't decide and considered it to be equal one way or the other, likelihood that it was prejudicial, that then the prosecution would lose?
Correct.
But otherwise, the question is, was there a reasonable likelihood, or I guess that's probably the language from the constitutional standard, but whatever degree of likelihood.
Yes, the question is always whether there's a reasonable probability or possibility. I know the cases have gone back and forth there. That is the question, but it is up to the state to affirmatively show that there is no such reasonable probability.
You were suggesting that the prosecution had a burden of coming forward with more evidence than is in the record as it is.
I'm not saying evidence outside the record, but the burden to make an argument based on the appellate record that clearly shows an absence of harm.
Let me ask you one other question. I don't have the statute right in front of me, but as I recall, the 1610-10 whatever that sets this out actually has a part that says a judgment won't be overturned for an irregularity or mistake in the process of selection unless prejudice is shown. Does that change that burden?
I don't believe that it does, because Novotny does characterize this as a harmless error analysis, and because this court has been clear that a harmless error is something that the state has a burden on.
Can I ask you, I'm sorry, and I know you talked about CA initially, but we're still in jury selection, and your belief is that juror CA was biased, correct?
Correct.
Why wasn't he excused with a peremptory?
I was not trial counsel, so I can't speak to that.
Is there an invited error issue there?
I do not believe there is. Martinez-Salazar also answers that question in the federal context, and I think that Martinez-Salazar adopted the appropriate rule there, that Peremptories are intended to be discretionary. It's up to trial counsel how to use them. And so imposing any sort of requirement on trial counsel to use it to cure an error detracts from the discretionary nature of a peremptory. The only context where the court exercises any control over the exercise of a peremptory is in the Batson context. I do not believe it would be appropriate to impose on trial counsel any sort of obligation to use peremptories to cure an error.
In determining whether the answers that juror CA provided warranted grant of the challenge for cause, is that something we can consider, that the party challenging him ended up not excusing him with a peremptory?
I don't believe so, because there could be very good reasons why defense counsel chose to exercise its peremptories on other jurors. Simply because those reasons didn't rise to the level of a challenge for cause doesn't mean that they were not very good reasons. And ultimately, especially since there's no record on why trial counsel made those decisions, I don't think that this court should assume that that means that the juror was not biased.
Come back to the Court of Appeals standard. You point out nicely that in Novotny, we pretty much didn't say it has to be a constitutional error, and we left open that question, I take it.
Yes.
Let's see how to phrase this. So would you, well, in Rivera, one of the cases we talked about, the U.S. Supreme Court, when they pretty clearly said, I guess, and I think we said in Novotny, that they said a problem, a mistake, an error, unless it was in bad faith with regard to selection process and use of peremptories, wouldn't implicate federal constitutional standards, which suggests this is a matter for us, I guess, either state constitution or statute. Is there anything in our statute with regard to jury peremptories, jury selection, that would cause you to believe our legislature intended that a mistake with regard to use of peremptories would result in an error that would cause reversal, or simply, as I think some of the cases in other jurisdictions have suggested, that the process of using peremptories and of selecting a jury is done the way it is in order to get a good jury. But a failure in some way doesn't mean you didn't get a good jury.
So I don't believe the statute really speaks to that one way or another, but I think as a general matter, when a statute or a rule of procedure is violated, that's an error. That's what appellate courts decide every single day. And requiring a constitutional violation to establish a statutory error is really going the wrong way around. Just because there's no constitutional error doesn't mean there was no statutory error. I will now turn to the third issue, if there are no other questions on the second. So the third issue was Sergeant Crown's testimony regarding the supposed visual match between the photographs that he took of shoe prints at the Caldone property and shoes that were recovered by the Alamosa Sheriff's Office from Mr. Vigil. By his own testimony, Sergeant Crown spoke about his extensive training and experience. He spoke about being certified as a crime scene specialist, and the prosecution capitalized on that when it offered his testimony regarding the match. I think it's telling to look at how the prosecution framed it to the trial court when the prosecution alerted the trial court that it would seek this opinion. The prosecution said that Crown was not an expert in the highest degree, but that he has sufficient training, which he'll talk about, to allow him to make an opinion about whether there is a match. So essentially, the prosecution was saying that he both is an expert and is not an expert. But the law knows no such middle ground. Testimony is either expert or lay. But what the prosecution ultimately ended up doing was presenting it to the jury as expert opinion. The questions were couched in terms of training and experience, and that is a factor that this court identified in Ramos as being relevant to whether the testimony was lay testimony or expert testimony.
Can I ask you a question there? I obviously didn't go through the record, and you have this, but so he got a part where he clearly says, based on his training and experience, but is there any suggestion in the record that was training and experience with regard to making a determination about the comparison of footprints, or was it merely training and experience as an officer gathering evidence, whatever, broadly?
So the testimony was, I would say that to a lay juror, it was ambiguous. He talked about being certified in evidence collection and crime scene process. I think a reasonable layperson would infer from that some sort of expertise in making these types of comparisons or offering opinions on the significance of a piece of evidence, not simply expertise in properly gathering it and preserving it. I think as people experienced in the system, we would probably read it as gathering and preserving evidence. But in terms of how it was presented to the jury, I think it really did come across as though it would offer him some special authority to weigh in on this match.
But did he introduce, I'm sorry, I was skimming back through the transcript and I wasn't seeing it. Did he suggest that his opinion that the shoes matched the prints was an opinion based on his training and experience?
The prosecution's question was based on training and experience. So I also don't recall whether his answers ever said based on my training and experience, but the questions were couched that way. And he was asked the question multiple times, and I believe certainly at least one of those times it was couched in those terms. I don't remember every occasion offhand. The Court of Appeals held that this was proper lay testimony because expertise is not required to make the comparison, and that it was helpful because Crown had personally observed the footprints, which the jury had not. The Court of Appeals got that part of the decision wrong as well, because Crown's own testimony was that he based the comparison on the photos that he had taken and the shoes themselves, which were things that the jury also had. So even if this court concludes that this was lay testimony, it fails the helpfulness requirement because by Crown's own testimony, he based his opinion off of evidence that the jury also had. If there are no other questions, I'll reserve my time.
You may.
May it please the court, Carmen Moraleda on behalf of the people. My attorney registration number is 34852. Oof, so much to respond to. So I'm going to start with the defense challenge for cause, then I move on to the prosecution's challenge for cause, and then talk a little bit about what I call the shoe-brain testimony. So here, in determining that the trial court did not abuse the discretion, the Court of Appeals appropriately applied this court's precedent. I mean, the ultimate test is whether the trial court is satisfied that the juror is able and willing to render a fair and impartial verdict based on the law and the evidence. And contrary to what defendants argues, this court has expressly concluded that a clear expression of bias is necessary to dismiss the juror. And this is in Carrillo, and Young, and Lefebvre. Just let me quote just a little bit from this court in Carrillo. This court said that the juror's answers to questions about his working relationship with the witness appear ambiguous and fail to articulate a clear expression of bias requiring his dismissal. And then this court went to compare or contrast the ambiguous nature of this juror with those at different juror in a different case, where she clearly said, I can't be fair and impartial. So that court there used clear expression of bias. The same in Young. This court there said the record in this case does not reveal that the juror had any clear bias against the defendant, which would make this dismissal from the jury compulsory. So the defendant is arguing that the court didn't mean what it said. It talked about clear bias. Here, the record supports the trial court's denial of the challenge. This juror made equivocal statements regarding whether it would be difficult for him to render a fair and impartial jury based on his relationship with the victims and the victim's family, but he did not clearly say he could not be fair and impartial. Particularly contrast what he said with the two other jurors who said, we can be fair and impartial because of my relationship or whatever it is. They clearly said that. In addition, the trial court followed up with a question. It said, can you assess this witness testimony just like any other witness? And the juror said, I think I could. And even though it didn't ask, can you be fair and impartial, I don't think the trial court was required to specifically ask that question. Because that question, that follow-up question, kind of tackled the grounds for the potential bias that this juror was indicating. And even if the juror's initial statements were equivocal, it was for the trial court to determine the intent and the state of mind of this juror from the statements, the answer to the follow-up question, and also all the nonverbal communications that we cannot see from the court record.
Why shouldn't it be incumbent on the trial court to ask whether you can be fair and impartial to both sides when a juror expresses what you're characterizing as these kinds of equivocal statements? Even if I accept your premise that it's equivocal, isn't it incumbent on the trial judge to follow up and make sure?
Well, the trial court needs to be satisfied that the juror can render a fair and impartial verdict. I mean,
but he didn't ask that. That's the problem, is it not?
Yeah. Would it be better if the court asked that? Sure, but if the court is satisfied that the juror can render a fair and impartial verdict, that's all is required. And the rule, I think, is worded in terms of if the court is satisfied by whatever the juror said or other evidence in the record that the juror can be fair and impartial, he can deny the challenge.
It seems like a kind of an erosion of what we've already come to accept. We say the trial court can ask a series of leading questions that most people, especially if they're nervous during jury selection and are being given kind of a pop civics quiz, are going to answer in a certain way, right? And we say, well, that's enough, even though some cynics might look at that and say it doesn't really demonstrate anything meaningful. Here, we seem to be going a step farther potentially and saying, well, you don't even have to ask you don't have to ask the series of leading questions. We can just sort of glean it from a question that's really dedicated to just whether you can judge a particular witness's testimony impartially. And so that bothers me. Can you help me with my concern about that?
Well, this court never indicated a clear bias. So it's not the case like a juror saying, I can't be fair and impartial. I think in that situation, the court has a duty to inquire further, to make sure that this juror can set aside that bias and render an impartial verdict. But in this case, the juror, in fact, the first response to the question of whether the business relationship, the question was, do you feel that it would be difficult for you to render an impartial verdict? And the juror said, I can't say that. I really can't. So the first response was, I don't think it would be difficult. I think I could do it. And then he said, I'd like to say no.
Well, I'm not sure that's right. I mean, he says, I can't say that. I'd like to say no, but I don't know. I think the fair reading is, I don't know if I can render an impartial verdict.
Yes.
Okay.
And that is an unclear question. That's not like a clear statement of I can't.
So
like
it requires follow-up.
Yes, and the court here conducted a follow-up, maybe not the most perfect follow-up, but it was a follow-up nonetheless, and asked if he could assess this juror's, this witness' testimony like any other witness, and he said yes, he thought he could do that, which meant, as the Court of Appeals here determined, that he could assess his credibility impartially, in terms means that he could render a fair and impartial verdict.
But let me, if I can follow up, Ms. Morleda. So one thing that I suppose troubles is there was a question in between, and I'd just like your reaction to it. Mm-hmm. So the defendant gave, the juror gave an answer that was somewhat equivocal. I can't say that. I'd like to say no. The defense counsel then followed up with the exact right question. Can you render an impartial verdict or not? And then the juror said, it's something that sits there. I know the people, I really do. I don't know the defendant here. So he was asked the exact question and didn't answer it. So we're still equivocating on when he can be fair. Wasn't it incumbent on that, at that point, for the judge to step in and say, you know, Mr. CA, I really need an answer to that question. Can you be impartial or not?
Well, maybe the court should have done that. But I think what he did was sufficient. And the question is not really whether we agree with what the court did. The question is whether there's sufficient record to support his ultimate ruling. So that's the question, even if we disagree. That's the question. And this court has emphasized that the trial judge is the only judicial officer able to fully assess the attitudes and state of mind of a potential juror by the personal observation. And it's very, on the court record, it's just very difficult to make those determinations. That's why this court emphasized we give judges this deference because they are the only ones who can fully assess the potential juror.
Can you respond? Were you finished?
Oh, I was, yeah. Thank you.
Could you respond to opposing counsel's assessment of Carrillo and how the facts there are really different because there was meaningful rehabilitation in Carrillo, but there wasn't here? Can you address that for us, please?
I think Carrillo supports our position. It's true that they generally asked about being fair and impartial, but in Carrillo, I believe that the judge did not specifically ask about whether he could assess the witness credibility the same as any other witness. And that's something that this court pointed out. And at the end of the day, in Carrillo, I think this court emphasized why trial judges are due that deference because they are there and can see personally the jurors' reactions and all the nonverbal communications.
But there was also, in addition to what Mr. Cox referenced, I recall that there was some talk about how he thought he might be able to be a blank slate. There was this blank slate exchange. And so that seemed to be a different factual scenario, quite a bit different from what we have before us here.
Yeah, that is, it's true that in that case, that question was asked. I'm not going to deny that. But I think if you look at the whole case, all the facts, ultimately, this court said that based on what he said and based on the unclear nature of the jurors' responses, it was for the trial court to ultimately determine whether he could be fair and impartial.
And I don't want to chew up your time having you go through that now. I appreciate it. Thank you.
Ms. Moraleda, in your brief, you quoted a question that the trial court judge asked, apparently of the whole veneer earlier on. Why is that relevant? What relevance does that have? Does that question have to our analysis of juror CA?
Because that was a question to the entire panel. Are you asking about the question of whether you can be fair and impartial in general? Is that the question?
If selected to sit as a juror in this case, will each of you be able and willing to render a verdict solely on the evidence presented at the trial and the laws I will give to you in my instructions, disregarding any other ideas, notions, or beliefs about the law that you may have encountered? Can all of you do that?
Yes, and this juror didn't say no. So that's further evidence supporting the trial court's ultimate ruling in this case. All right, so unless there are more questions on this issue, I would like to move on to the next one. I think I argued in my brief, and opposing counsel had not addressed this. I know this is not within the letter of the cert issue, but our position as the prosecution's defendants claim that the trial court improperly granted the prosecution's challenge for cause is waived. As I said in my brief, the defense did not object to the prosecution's challenge and did not object to the trial court granting the challenge, and that under Rule 24, that claim is waived. And because it's waived, this court should not even address the claim. Even if it's not waived, the record amply support the trial court's decision to grant this challenge. Juror DK made statements demonstrate that he was not able or willing to render a fair and impartial verdict because he was inclined to be in favor of the defendant. Let me just briefly read something that this juror said when asked by the prosecution. He said, I'm going to be blunt here. Nobody wants to be on the jury duty. I'm going to say this. I would just as soon let somebody off. My tendency is for my heart to be in favor of the defendant. I would like to think the best of most people. And then when the prosecution asked if he was predisposed to let the defendant off, he said, I'm predisposed to let him or his mouthpiece have their say. Then during defense questioning, this juror, counsel asked, well, this juror first said, I understand that we are presumed innocent in this country until found guilty. And then counsel said, is that what you meant earlier about sympathy or something about the defense? And he said, that is not exactly what I meant, no. You got it right. I'm a big-hearted guy. I would rather let things slide. Then counsel also asked whether he was a forgiving person. And he said, some things should not be forgiven: murder, rape, incest, thievery. And then the defense said, Your Honor, I would pass him for cause. And then the court allow the juror to step down. So there is plenty, ample evidence in the record to support the trial court ruling granting the prosecution's challenge for cause.
What about his his response? He is specifically asked what CA wasn't. Could you render your verdict solely based on the evidence in the court's instruction? I believe so. I take this seriously. He had prior experience in the justice system. Do you think it would affect your ability to serve? I wouldn't think so. I take this seriously. It's a responsibility. There are hundreds of Court of Appeals cases, some which I sat on, where once the defendant, and it's usually the defendant's challenge for cause, and that as soon as the juror says, I can be fair and impartial, I think so, judge says denied, and your side argues enough. This guy said 100 times, I could be fair, I'll afford the presumption of innocence. Why is this different than when the shoe's on the other foot? You seem to be arguing exactly opposite, and I say this most respectfully, opposite of what many cases you're arguing the other side of this. I mean, there's a pretty good argument. This guy is the quintessential juror. He gets it. He gets the presumption of innocence, and he's struck. So help me with that. Help me understand the consistency with all these hundreds of cases where as soon as a juror says, I think I can be fair, good enough, this guy said it in spades. So
the question is whether we agree, as I said, with the trial court. The question is whether there is record to support. And here, there are things this juror said. He said, I'm inclined to let him go. He said he believed in the presumption of evidence, but he also said things that supported the court or made the court maybe not being satisfied that this juror could or would render a fair and impartial verdict.
So help me with that. You said, arguing say, there has to be a clear expression of bias. What did he say where there is a clear, I'm with you. Yes. He said stuff that if I'm the prosecutor here, I have some concern about, and I probably don't want this guy in the juror. But he also said I could be fair. So where's the clear expression of bias? Why isn't this a peremptory challenge and not a challenge for cause?
Well, because he said things like my tendencies for my heart to be in favor of the defendant. And when defense counsel asked about the presumption of innocence, he said, no, that's not really what I mean. Is I'm a big-hearted guy. I would rule in favor of the defendant. And then the credibility or sincerity of this juror was for the court because we were not there to see that. We don't know how he said it. We don't know those nonverbal communications that we just totally missed from the record. And that's what is for the trial judge.
I apologize I took so much of your time on that. If it's okay, I'd really like to hear your argument on the prejudice piece of this because I find this to be a very difficult question.
Yes, so, but quickly, we are arguing this issue is waived. So there's nothing to review, or there's no claim to review because the trial court properly granted this challenge. But moving on to the harmless issue, our position is that in this case, because defendant got a jury that was fair and impartial, the error is harmless. Under Rule 52, an error is harmless if it doesn't affect substantial rights. Defendant's substantial right, his right to have a fair trial by an impartial jury, was respected. It wasn't affected, it wasn't violated. So even if it was an error in granting the prosecution's challenge for cause, as long as the defendant is tried by an impartial jury, that error is going to be harmless.
Can I ask you then if you would respond to Mr. Cox's argument that this would be a rare situation where we assess harmless error based on whether a different constitutional violation happened, and why doesn't this lead to an automatic affirmance rule?
So I know they kind of characterize this as a different constitutional violation, but he argues about the violation of the rights that I have, the statutory rights that govern voir dire and that govern peremptory challenge. But those statutes are the means to an end. Those statutes are there to ensure the defendant gets a fair and impartial trial. And as long as he gets that, that's the end of the inquiry. So even if it's I wouldn't say automatic affirmance, but even if it is automatic affirmance, if the error is harmless.
But it would always be harmless because if a biased juror sat, you have a different Sixth Amendment violation. So when would it ever be harmless error to strike for an erroneously granted prosecution challenge?
It might never be the case. It might be the case that it's always going to be harmless because if the defendant gets a fair trial by impartial jury, and I'm going to repeat this, what is the error? There's no error. The errors will be harmless. There's nothing wrong with that. Only means that there's really not cognizable prejudice in this case, under these circumstances. If the defendant gets a fair trial by an impartial jury, regardless of whether there was some kind of deprivation of the peremptory challenges, the error will be harmless. There's nothing wrong, even if we were to find that error harmless if he gets a fair trial with impartial jury.
So, did you have a follow-up?
Nope.
Chief, did you want to jump in?
I was going to ask one question on that. So go back to Mr. Cox's response to my question about what there is in the statute that suggests this is only a process for picking a fair jury, but error in the process shouldn't amount to overturning a judgment at all. What is there in the statute that says that? As he points out, usually if we say the statute says you get this or do this, if that's violated, usually we then consider that error and we look to see if it's harmless in itself. But here, you seem to be saying that's not the case. Rather, this is just a process to get a fair jury, and unless the ultimate fair jury wasn't fair, then we don't have to worry about it. I'm not sure what there is in the statute that suggests that.
Well, I guess this is the way that it has been interpreted and all.
By the Court of Appeals?
No, by this court, also in Novani and Alfaro, when talking about peremptory challenges and all that, even if there is a good faith but mistaken deprivation of any of the defendant's peremptory challenges, in whatever form that deprivation might take, is not in itself grounds for reversal. This is this court in Alfaro. So,
as your opponent points out, though, we had a sentence that was very express in Novotny that said, we're not saying this only has consequence or a remedy if it turns out to be a constitutional violation, right?
And I think the way I read this court's those cases is if the trial court is doing something in bad faith, like denying all of defendants' challenge for cause and granting all the prosecutions. That's kind of like a little bit separate claim, but I read that if the trial court is doing something other than in good faith, as this court had pointed out. So that's the way I read that. Maybe that case, there's some violation of the statute that is separate from the Sixth Amendment violation. Any other questions on the harmlessness?
Well, all of this reminds me of a question I meant to ask about. If we disagree with you on CA, and so we have to assess that error. I gather you agree with his assertion that Martinez Salazar would cause that to be structural error, and therefore it would have to go back.
Yes, if this court finds that the trial court abused discretion and finds that the juror was biased, I think we agree that it would require reversal and new trial.
And of course, if that's the case, then it arguably moots the need to address the second issue altogether, doesn't it, other than the fact that the Court of Appeals opinion was published?
Yes, yes.
If I can follow up, Ms. Moore, later on the prejudice piece again, if we agreed with the argument, the no bias juror sat test, how does that square with Hagos' statement of what harmless error is? Hagos talks about whether the error substantially influenced the verdict or affected the fairness. I guess you would say no effect on the fairness. Is that?
Well, yeah, because there's not a violation of his substantial rights, as the rule defines harmless error, Rule 52. Yes.
And his substantial rights here would be the right to a fair trial as opposed to the right to have appropriately challenges for cause addressed appropriately? I guess maybe I'm picking up on what the Chief was asking. It sounds like we're in the realm of Sixth Amendment fair trial regardless of the statutory rights.
Yeah, but the statutory rights, as I said, it's true they are the means to an end. So if he gets an impartial jury, there's no violation of his substantial rights, and therefore the error is harmless, even if that the court erred in granting the prosecution's challenge for cause. And I would like to quickly point out too that harmlessness in this context should not and cannot be measured based on a defendant's deprivation of a particular juror with particular points of views and particular opinions, because it is well established that defendants are not entitled to a jury of any particular composition. And that's the claim, that's the premise of the defendant's claim, that he was entitled to have this juror with this particular views and this particular opinions. And that's well settled that he's not legally entitled to that.
So if we adopt this rule, and I'm just struggling with it, so thank you for your patience with me, doesn't that create an incentive for the prosecutor just to move to strike every single juror it doesn't like for cause? Because there's no risk. I just strike everybody for cause, and if I win, great. If I don't win, no harm, no foul.
Well,
that seems to be an absurd result.
But we're assuming that the trial judge is going to grant all those challenges. I mean, that's what we have trial judges to determine, based on the merits of the challenge, whether to grant it or not.
May not, but there's no risk. And I assume total good faith on the prosecutors too. A good prosecutor seeing this rule just strategically may choose to, if it's a close one, I'm going to move to challenge for cause, see what happens.
Then the prosecutor has to think about his reputation and credibility with the court and doing something that is, not doing something with an ill will, but for a good reason and strategically, but again, not with ill will. And that's why we have trial judges who will determine whether to grant or not. It's ultimately for the trial judge. And I don't think that should incentivize prosecutors to do, we're assuming that they're going to do something for the wrong purposes, and I don't think we should assume that. Let's see. Wait. So I guess now I have 4 minutes to talk a little bit about the shoeprint testimony. Yeah, this. So I think the Court of Appeals here, the holding that the sergeant's shoeprint testimony was lay opinion, was correct under this court's precedent in Stewart and most recent test in Vin Alonso. Also, it was in accordance with the majority of jurisdictions that have addressed this issue. This court in Vin Alonso clarified that to determine whether testimony is lay or expert, I'm just going to quickly quote and read, said, a trial court must look to the basis of the opinion if the witness provides testimony that could be expected to be based on an ordinary person's experiences or knowledge, the witness is offering lay testimony. If the witness provides testimony that could not be offered without specialized experiences, knowledge, or training, then the witness is offering expert testimony. So here, opining whether the shoe prints matched the shoes or whether they were similar, particularly where the brand name Skechers was imprinted in the sole, could be based on an ordinary person's knowledge and experience by mere observation and ability to read and use everyday rulers, and did not require any specialized knowledge, training, or skill. And therefore, the Court of Appeals properly concluded that that testimony was properly admitted as lay opinion.
Could I ask, I'm sorry,
Yes,
this
please.
is as a matter of a record question, could I ask the same question that I asked of your opposing counsel? And were the questions and the answers in terms of the match couched in terms of based on your training and experience? Because we made a big deal about that in Ramos.
Yes, so the prosecution discussed the training and experience, but that this officer had, as they generally do, but there was no testimony that this sergeant had any experience in shoe print comparison at all. I haven't found anything. And I know defense opposing counsel talks about the prosecution couching part of the testimony on training and experience. And that actually happened during recross. And let me read because this is really, okay. Page 99 of the PDF. So he says, obviously, we have not admitted you as an expert. And then he said, the prosecutor, but in your experience and training as a police officer and not as someone who's been admitted as an expert, did you come to any conclusions? The defense objected, and the trial court actually sustained the objection. So to the extent that that was said, sustained the objection, so we have to presume that the jury did not even consider that. And then the court said, he's made, without belaboring the point, he's made his comparison and said they visually matched. And it's true that the officer on the stand testified with the photographs of the shoe prints and the shoes and said, yes, they match. But before that, he had testified that when he went, and I have 1 minute, when he went to the Alamosa County Jail, he saw the shoes and they believe they match. And at that point, I don't think he was relying on the photographs. So that was additionally helpful to the jury. And to the extent that the testimony, seeing the photographs and the shoes, was not necessary, it was harmless because the jury was given exactly the same evidence. The shoes, the photographs, the scales. And also, as I point out in my brief, the evidence of defendant's guilt was overwhelming, circumstantially overwhelming, because he was caught driving the victim's pickup truck with the motorcycle and the pickup truck. And also the jury, that together with the shoes and the prints, that was overwhelming circumstantial evidence that he also committed the burglary, not just the thefts. And with that, we request that the Court of Appeals judgment be affirmed. Thank you.
Thank you.
Starting very briefly on the first issue, opposing counsel talks about the trial court's discretion to read nonverbal cues that we don't get from a cold record. We agree with that position in general, but there's still, that is about the trial court's discretion to decide between conflicting statements and decide which ones are more genuine. Here, there were no conflicting statements. His only statement about his ability to be impartial was that he doubted it. So it's irrelevant what body language he may have exhibited at various points that we don't have in the record. Turning to issue 2, the issue is not waived by saying that the defense passed DK for cause. The defense was making it clear that it opposed the challenge. Throughout voir dire, that phrase was used to say that a juror was acceptable to the defense. The one occasion where the defense consented to a challenge, the defense said, I concur. That's not what happened here. This is not waiver. In terms of the merits, I believe, Justice Gabriel, you got it right. When you said that this was the quintessential juror, he said that he would honor the presumption of innocence. These are things that we want in jurors, not things that should support a challenge for cause. And then in terms of the harm question, the question that this court granted certiorari on, the substantial right is a jury that is constituted according to the rules that govern jury selection. The substantial right is not solely limited to the Sixth Amendment right to a fair trial by an impartial jury. If every time that a jury was constituted that was fair and impartial, if that was sufficient, then there would be no need to have peremptory challenges at all, because presumably the court's ability to correctly rule on challenges for cause would be enough. So
Real quickly on this seems to be the part of our argument, even though you don't have much time. But how is it, even if we accept what you're saying about evaluating harmless error, that doesn't bring us down to a question of deciding whether the juror who actually sat would have been more likely to vote to convict than the juror who was let go?
Well, I think that it does come down to how that juror's views might have influenced deliberations. Of course, neither the trial court nor the appellate court is there in the jury room, so we don't know for sure, but I do think it comes down to looking at that juror's statements. One other facet of harm I'd like to very briefly point to, the Lane court in Pennsylvania pointed out the impact on the rest of the panel. So when a juror is dismissed for saying that he'll honor the presumption of innocence and so on and so forth, the rest of the panel hears that and will conclude that that's bad. We ask this court to reverse the Court of Appeals. Thank you.
Thank you. We appreciate the arguments of both counsel. This case is going to stand submitted. The court's going to be in recess for 15 minutes. Please be seated. Next case on our docket is styled Owners Insurance Company versus Dakota Station 2 Condominium Association. We've set this one for 1 hour, obviously half hour per side. Petitioners, you can reserve whatever time you want, but you're responsible for keeping track of your own time, right? Please begin when you're ready.
Mr. Chief Justice, and may it please the court, I am Evan Stevenson, attorney registration number 37183. I represent the petitioner Owners Insurance Company. This case is about the integrity of the insurance appraisal system in Colorado. To protect the integrity of that system, this court should reaffirm the principle from its own decision in Providence versus Goulinson that appraisers who are required by the insurance contract to be impartial owe the same duty of impartiality as an arbitrator. The court should define the term impartial the same way here that it did in Knopfsinger versus Thompson, quote, to be without the slightest degree of friendship or favor toward either party, unquote. The Court of Appeals did not apply this rule, and its judgment should be reversed for 2 reasons. First, the Court of Appeals did not apply the plain meaning of the term impartial to insurance appraisers, as required by both the contract's plain terms that both sides agree to and by public policy. And second, contingent cap agreements entered into by some appraisers, like the agreement here, eliminate appraiser impartiality as a matter of law under any definition of that term, including the Court of Appeals definition. Reversal is therefore necessary, even if the court defines the term impartial as did the Court of Appeals. Now, first, the term impartial in an insurance contract's appraisal clause should be given its plain and ordinary meaning. The purpose of the appraisal clause and the purpose of the impartiality requirement is to provide a remedy in Colorado and other states where this language is used that is speedy, inexpensive, narrow, and efficient. It's designed for the average claim, a claim that's generally much smaller than this one. The Dakota Station claim is in the tippity top of the highest 1% in terms of size and complexity. The appraisal clause is designed for the average claim. Usually, appraisers are appointed. They're both impartial. There's no fuss. They agree.
Mr. Stevenson, let me ask, it strikes me that the insurance company is an advantage here because they're going to have recurring use of adjusters. And, you know, if the adjuster comes in with an unfavorable amount for the insurance company, their remedy is to just not hire him again, where the insured is only going to use them on a maybe once in a lifetime basis. Help me with sort of that assertion of why shouldn't we equal the playing field a little bit?
So I disagree with the premise of the question, Your Honor. I do not agree that in an impartial system that insurance companies have any advantage. And to the contrary,
Only use your adjusters one time? Or do you have adjusters that are used over and over and over again?
Insurance companies will sometimes use the same appraiser repeatedly, and others take other measures to ensure that the circuit is broken between their selection of the appraiser and who is selected. So, for instance, some insurance companies will have a contract with a third party that chooses the appraiser to address that issue. But in any event, the impartiality requirement, if that were a concern, if repeated retentions were creating a problem of partiality, the solution is the impartiality clause. The last thing the court should do if it has that concern is stop enforcing it, as effectively the Court of Appeals has done. And the Division of Insurance, its job is to look out for consumers with small claims. The Division of Insurance has addressed this issue. The Division of Insurance's solution is not less impartiality, but more.
So I have to ask, because the thought bubble in my head keeps screaming at me here, be careful what you ask for. Your appraiser, the record here shows, gets 90% of his business from owners. How is that appraiser impartial under your definition? Has to have the impartiality of a judge, basically.
Several responses to that, Justice Gabriel. First, the record does not show that. That is not accurate. That claim that's made on page 5 of the answer brief is untrue. There are 2 citations to the record to support it. The first citation is to testimony that wasn't even Mark Burns, although the brief says that Mark Burns said that. It was the testimony of Scott Benglin, the public adjuster, who had no personal knowledge of how much business Mark Burns had. The second citation is to Mr. Mark Burns' testimony, but on the page cited, he nowhere says anything about how much business he received from owners, and it just simply isn't a true allegation. Second response. Even if it were true that Mark Burns were biased, the remedy would not be to affirm the appraisal award. That would be asking this court to rule that 2 wrongs make a right. Third response. Courts have heavily litigated this issue of repeated retentions, and there is a consensus among the lower courts that have addressed this issue. And it is that retaining an appraiser repeatedly to be neutral does not by itself mean that that person is partial. Now, it's a factor that can be considered, depends on how many engagements, how much money. It's something that should and can be looked into. But by itself, it is not disqualifying. And so I have no problem with that rule. And my client has no problem with that rule. And if someone has a problem with the number of engagements that Mark Burns or someone else has had with an insurance company, let's talk about it. Let's talk about it before the appraisal. Instead, as the Court of Appeals requires, after it is over a year later, hundreds of thousands of dollars into it.
Can I ask you, while I've got your attention, a
Yes.
slightly different question just about the insurance agreement here. It talks about the parties each selecting a competent and impartial appraiser. Each party will select. What does that language mean? And so I'm not hiding the ball on you. Where I'm going is there some ambiguity here that ultimately would result in construing against the insurance company? One could hypothetically argue, I'm just throwing this out there for discussion, you've got to select someone who's competent and impartial, meaning disinterested, no financial relationship. But then the rest of the clause suggests perhaps there could be some advocacy. You each got your own, and then you get an umpire if you disagree. So help me understand how you perceive the clause. Do you see it, any ambiguity, et cetera?
I see no ambiguity in the clause, Your Honor. I think the word select has its ordinary meaning, which is that the policyholder will name someone and the insurance company will name someone. I don't think it's any more complicated than that. I think the term impartial has the same meaning that it's had in every context in Colorado where someone finds facts. And I don't think that the structure of the appraisal process creates ambiguity in those terms. I think that's the real gist of your question, is a system where parties appoint 2 sides may suggest to some that there's some advocacy going on. Am I following your question?
Yeah, that's why I was asking. Because, again, so I'm not hiding the ball. You could read this, arguably. You got to select someone who's impartial, and that just means, hypothetically, disinterested party, no ties, not tied to the parties in the case, no financial interest in the case. But then after that, there's an understanding that there will be some advocacy going on both sides, and if they disagree, they get an umpire to fix it. One could at least construe that, arguably, to suggest that's what will happen.
Yeah, so I don't view that as an ambiguity argument, first of all. But secondly, the way it normally works, there isn't advocacy. Generally it's 2 roofers or someone who's, 2 people who are technical experts who go up on a roof with a clipboard and check off what they think needs to be done or check off things that need to be repaired. It's designed to be a adversarial process. The fact that people are selected is an inevitability, and I don't think the fact that people are selected implies advocacy. And let me give you an example of why I think those 2 ideas are compatible. So the civil rules give us 2 examples of people that are paid by one side, but are still expected to be unbiased. So take the Rule 35 of the Rules of Civil Procedure. Rule 35 examiners appointed by courts are not expected to be biased or partial, but they're generally paid by one side, even when they're court appointed. Rule 53 governs the appointment of special masters. There is case law requiring one side to pay the special master. Special masters, under the rules of procedure, are expected to be impartial. I would say under the same definition as Knopfsinger. So I don't see an inherent or dispositive inconsistency between someone picking somebody and a process that's impartial. I mean, I think that conclusion would go too far, because it would make it so that it's impossible to have any system that is based on a non-adversarial impartial process if simply picking someone or paying someone precluded it.
All right, thank you so much. If I could ask just one more question, and this is, I guess, a concern that's in the back of my own head, is doing something that upsets the entire industry here. So maybe you can address industry standard on how this works. I mean, there's a lot of amici here who are very concerned about this case.
Yes.
And I fear doing something that, throws the whole world into disarray if hypothetically everybody understands that there's some advocacy going around. Could you help me with the industry standard here?
Yeah, so I disagree with the amici on the Dakota Station side of the case. I think the industry standard is to pick someone who has not been used as your expert before, usually. If the clause requires impartiality, you generally don't pick someone who's been your employee. You generally don't pick someone who's your family member or blood relative. But you can pick someone who you've used to be neutral before. I think that is generally the industry standard. And another industry standard, and you saw it in this case, is generally the insurance companies don't communicate with their appraiser while the appraisal is going on if there's an impartiality requirement, because they don't want to influence that person. I'd say that's another industry standard in cases like this. I mean, if you're talking about industry standards and what the law is across the country, I think it's very clear that if the policy says impartial, it means you can't favor one side more than the other. And that's really all you need to decide today. Now, I agree that there are other things that can be discussed relevant to appraisals.
Mr. Stevenson,
Yes.
Can I ask, what was Mr. Burns' estimate for the damage here?
So his estimate for the roofing was about $1.8 million. And his estimate for the total, I believe, was around 2.3. I'm going off my memory here. So I think that's very good evidence that he was not advocating for owner's position.
And what was Ms. Haber's estimate?
It was around $3 million. And the appraisal award came back at $2.95 million.
And that's what the umpire came back with?
Yes. When I say the appraisal, I just mean the award that was signed by the umpire and Ms. Haber. Yes.
Okay.
So returning to the nature of appraisal, usually appraisers agree. And there are very few procedures in appraisal. There are no rules of evidence. There are no rules of procedure. The umpire does not act like a judge. The umpire doesn't have the powers of a judge. Impartiality is the only protection, and I guess impartiality and competence are the only protections for both sides. And it's designed that way. It's designed so that it's not a formal process. It's an informal, non-adversarial process that is made fair by the fact that everyone participating is required to be as impartial as an arbitrator.
Can I jump in? Sorry.
Yes.
I'm going to piggyback on some of the questions from Justice Gabriel. I worry about what this will do moving forward. It strikes me that saying everybody or all the appraisers have to be impartial in the sense of what a judicial officer is expected to do, that can lead to all kinds of arguments in the future about whether somebody was impartial or not. It's going to open appraisers up for criticism and attacks on impartiality. And, we know a little something about impartiality being judicial officers.
Right.
So can you address that concern for me, especially in the context here where somebody is being retained by one of two opposing parties, right? There's a dispute, and each side is retaining a different appraiser and paying a different appraiser. Judicial officers are not retained and paid by one of the parties that appears before them. So I worry about, is this going to lead to litigation and arguments about, that appraiser was not impartial?
I think there'll always be some people who don't play by the rules, and there will always be some cases like that. But I think there will be far more litigation if you move to an adversarial system, like Dakota Station is advocating for. An adversarial system where there's no expectation of impartiality in the sense of Nossinger, and where parties are simply allowed to openly come to the appraisal pre-committed to the exact position that the parties already have and already disagree on. There you're going to have more litigation. You're going to have the appraisers never agreeing because they're going to be asked at the outset to advocate for the party that selected them. They're going to show up and going to have the exact same position that the parties who already disagree already have. What will happen if you reverse and follow the cases that have been developing before Dakota Station? What will happen is you'll see something more like the Villarreal case or the Summit Park case, where the judges there, the federal judges, entered orders or had guidelines, sometimes they're done by agreement, to govern the process in advance. You'll see things like the Division of Insurance's bulletins on appraisal take root, where at the beginning of the appraisal there are disclosures. How many times have you retained this person? What other relationships do you have with this person? That's how the judiciary has been managing this before Dakota Station, and it's been successful. If those cases are overruled, which affirming Dakota Station would effectively do, you go to a system where there are no disclosures, where appraisers will never agree. You'll have an umpire in every single one of these because the appraisers will show up to the appraisal on day one pre-committed to what the party's position was when the dispute arose.
I read the bulletin that describes or has some guidelines about appraisers, and it seems to talk about appraisers who are fair and competent and how you define fair and competent. And it talks about making sure that they're not interested in the case, they're not a party to the dispute, they're not a family member, that kind of thing. But it doesn't say anything about the final product. In other words, what about a system where the person selected pursuant to the agreement is in fact impartial? The appraiser selected by each side is impartial. And then the guidelines apply in terms of making sure their work is legitimate, in good faith, that there's nothing illegal going on. Do you see problems with that system as well? You think that's going to lead to a lot of litigation?
I just want to make sure I understand the question. So the question is, if we use a system like the Division of Insurance Bulletin, where people are screened up front and they really are impartial, and we save challenges to the substance until the end, does that create a lot of litigation? Am I understanding that correctly? Right.
The challenges at the end would presumably be resolved by the umpire. Right?
They could be. They could be.
Yeah, so what about that system?
Yeah, I actually don't, at least just my experience, is that you generally don't see as many challenges of that nature where they get to the end, everyone agrees it was an impartial process, and then you have a lot of litigation arising from that. There was a recent case called Andrews Trucking that they've cited in their Notice of Supplemental Authority where there was a challenge to the way the umpire averaged the estimates. But I find that to be an odd case, an unusual case. So in my view, if you can get this right on the front end, if you screen out the people who should not be appraisers through a disclosure process, which is what the Division of Insurance has been wanting to do, which is what Summit Park aimed to do, which is what other judges, Villarreal, which is what was happening in the federal courts before Dakota Station came along. If you have a system like that, you're going to have far fewer appraisal awards being challenged, much more instances of fair appraisals, more appraisers agreeing, fewer umpires being appointed, and less judicial intervention to appoint umpires. At Dakota Station, if you're worried about satellite litigation, is the exact wrong direction. Impartiality and screening at the front end is so much better for avoiding litigation. That old saying is true. An ounce of prevention is worth a pound of cure.
So, Mr. Stevenson, a couple of questions. You mentioned judicial intervention to select an umpire, but the contract here, an umpire, there's no judicial intervention necessary to select an umpire.
If the appraisers cannot agree, then a court appoints the umpire under standard clause, and I believe in this clause as well. Yes. So, and that does happen. There are examples of appraisers not agreeing on the umpire and then having to go to court to
see.
get
Okay.
the umpire appointed. I'm sure it is in this.
And in this case, how did the umpire reach her or his conclusion about the damage amount?
So the umpire in this case, and just, well over 80% of the award here just comes from the roofs. So, that's really almost the whole appraisal is the roofs. What happened was the umpire here, I think he believed his role was just to pick one or the other rather than come up with his own independent analysis, and I think that's a question for another day. But I think what he did is he just picked whichever number he agreed with as to each element of the appraisal, and for the roof, which was really almost the whole appraisal by itself, he picked Laura Haber's number.
So I don't know what he believed. I don't think it's part of it, but was he impartial?
I don't see anything in the record to suggest that he's impartial. However, an umpire alone cannot enter a valid appraisal award. If Laura Haber is disqualified, there's only one person standing who supports the award, and that would be the umpire. And under the procedure in the policy, one person cannot enter a valid appraisal award. And there are many cases to that effect, including in Colorado. In the Summit Park case, the umpire was not disqualified, but the appraiser, George Keyes, was, and so Judge Babcock vacated the appraisal award. Same thing in the Colorado hospitality case. It's well established that an umpire alone cannot sustain an award.
But is it relevant to our analysis, at least to how we think about it, that in this case the umpire actually looked at this and saw about the same thing that Ms. Haber saw?
I don't think we can assume that. We can't assume that he saw the same thing Laura Haber saw. I do think that advocates who stretch things can contaminate an appraisal award, including the perspective of the umpire. I mean, the last thing you want in an impartial process is an advocate who's posing as an impartial person who might be saying things to the umpire that aren't correct. So no, I would not take for granted that the umpire here saw everything the way that Laura Haber did, or even knew. I mean, actually, the umpire here is a mediator who doesn't have the computer program that Laura Haber used, has no construction experience. There's no evidence he went on the roof. There are all kinds of reasons. I mean, I'm not trying to argue the facts, but I just don't think we can assume that just because the umpire picked that number, that he actually did all the analysis necessary to reach that conclusion or adopt that premise, Your Honor.
You've mentioned Villarreal a couple of times, Mr. Stevenson. In that case, as I recall it, Magistrate Judge Verhollich kind of looked at the bulletin. He said, appraiser in the bulletin is defined as competent and fair.
Yes.
Umpire is fair, competent, and impartial. Yes. This gives us some guidance on what impartial means. Would you adopt that standard for kind of the umpire standard from the bulletin as the standard for impartial, or is what if you were to write the opinion for us and say, here's what impartial means, what would you want us to say?
I like Judge Terry's dissent. I think it's great. And yes, I would adopt Judge Terry's dissent. And I do think that the definition of impartial from the bulletin that applies to umpires, I think that would be another, I think it's the same. I think it's the same standard. I also think the Knopfsinger opinion, if you were to quote a key case to define impartial, I think the Knopfsinger case gives you the right language. I think all those things agree with each other. I don't think that there's any daylight between Judge Terry, between the impartiality definition in the latest bulletin, or Judge Terry's dissent. I think they all agree. In fact, I think there's only one definition that's ever been recognized for impartial fact finders in Colorado until Dakota Station. I believe it's an aberration. And so there's a wealth of places you can go and reach the same result.
And if I can move you to the contingency fee cap, I'd like to hear what you want to say about that. And I suppose the first question is, I'm troubled by the fact that you all can't even seem to agree on whether there's a contract. Could you, I suppose, if I understood the other side, it wasn't initial, therefore it's not a contract, but I'm not 100% sure I understand that. Could you tell me, first of all, your argument on why we have this 5% contingency fee cap agreement?
I mean, the argument on whether it is in there or not, is that
yes.
right? Yeah, it's definitely in there. So it's in paragraph 6 of the written order by the trial court. It's court file page 360, and the part they're quoting, they think they've just misunderstood what the court was saying. This is what they point to. The language that they point to says, the evidence is clear that neither party thought that the 5% cap applied to this case. But if you keep reading, what the judge is saying there is that Laura Haber's fee didn't reach the cap, not that there was no operative 5% provision. So later in the opinion, In fact, in the same paragraph, on the same page, the judge says, had an issue arisen as to whether or not the 5% cap limited Ms. Haber's recovery, it appears to this court that a court would have found that it does limit her recovery. And again, same paragraph, same page. The court finds that it is not an issue in this case, again, because he thought that or she, in this case, thought that the cap didn't actually limit Ms. Haber's fee. But if it had become an issue, the court believed it is likely that the document would have been construed against Ms. Haber, and her recovery would have been limited to 5%. And the court reasoned that because there were no initials by 5%, that it was ambiguous whether it was in the contract, but that the ambiguity would be construed against Ms. Haber and it would apply. So I don't think there's any question that there was a 5% limitation in there. And the Court of Appeals didn't think it was giving an advisory opinion and addressed the merits of that. So I think they're just wrong on that issue with respect. As to the merits of the contingent cap issue, this provision gives Laura Haber, in this case, an incentive to increase the amount of the award. And the only analytical reason that was given below for why this wouldn't be the case was that Ms. Haber's fee didn't actually hit the cap, and so therefore it didn't have any effect. But that reasoning is backwards. That's exactly what the provision incents the appraiser to do. So Laura Haber shows up at the appraisal. She doesn't know where Mark Burns is going to come in, and with an umpire, you generally have a split the baby result. And so what the cap does is it tells Laura Haber, let's pick a number that's so high, $3 million more, so that even when the baby is split, I can still get my full fee. So another error by the Court of Appeals is they didn't realize that the amount Laura Haber charged is in the record. It's in paragraph 2 of the court's written ruling, court file page 358. The court said that the appraiser's bills came to more than $50,000. This means that Laura Haber has to make sure that the final number is at least $1 million because she has a 5% cap. So if she comes in at $3 million, and let's say Mark Burns had agreed with owners and came in at $17,000 replacement cost value, you know, she's actually right. That's exactly the model we're worried about. Is appraiser comes in really high so that the compromise number by the umpire that splits the baby is high enough she still gets her $50,000. If it's all right, I'd like to reserve the remainder of my time.
You may.
Good afternoon, Your Honors. My name is Jonah Hunt. I represent the respondent, Dakota Station 2 Condominium Association, in this proceeding. Some of the volunteer board members are following along online, so I would like to recognize them. Also in the crowd is one of the amicus parties, Colorado Trial Lawyers Association, Mr. Roth for that association. Justices, I guess first I would address the burden of proof that owner's insurance company faces on appeal, and I'm glad that opposing counsel raised the Andres trucking case. That case was entered after briefing closed in this particular case and stated that appraisal awards, like arbitration awards, are held to, they're granted quite a bit of deference by the reviewing court, and they're not to be set aside unless entered as a result of fraud, accident, or mistake. So the lower courts, the trial court and the Court of Appeals, correctly determined that appraisal is not akin to arbitration and that Colorado's Uniform Arbitration Act is not applicable to these proceedings. But what's interesting is, in what I think should be impressed today before we move on to the issues upon which cert was granted, are that there was a trial in the trial court. There was a 2-day evidentiary trial where there was evidence and there was testimony. And the lower court, Judge Munch, stated even the insurance company owners agrees there was no fraudulent misrepresentation and no fraudulent concealment. And frankly, a failed fraud claim does not constitute a successful attack on the impartiality of the association's appraiser, at least not without substantially more evidence than has been shown in this case. So, at trial, owners they tried to prove fraud. They alleged fraud. They had no evidence of fraud. They couldn't prove fraud. They failed to do so. I would submit that under the Andres Trucking standard, the burden of proof has not been met. I understand the issues before this court are legal issues, academic issues almost relating to the appraisal process, but I do think that it's inappropriate for owners to effectively be challenging and I think in some places in the briefing misstating the factual record, because the factual record's important and it should be given deference by this court. I think what I'll do is go in reverse and address the contingent cap issue, because I think that probably is going to take up less of the questioning and less of the time for the court. There was a statement made just a few minutes ago that it wasn't clear, or that it was clear that the cap was in effect, and that the trial court made that determination. That's actually not true. The court file, page 311, paragraph 6, also referenced paragraph 3 of the appellate decision, stated, "Now it is true that the document anticipated that the particular provision being initialed by the parties, if it was to apply, wasn't initialed by anyone." So he's talking about the contract and he's talking about the contingent cap. Also at trial was testimony by the association's appraiser, and in response to questioning from owners' counsel at trial, the appraiser testified, "You were paid $150 an hour, yes. Was that subject to a cap? Not on this claim, no. So did the cap apply here? No."
But I mean, my problem is, did the cap apply could absolutely mean, and I will say directly, I read it the same way Mr. Stevenson did. We just didn't get to the cap. Mm-hmm. At least it's ambiguous. So right. The question, is it your position that there was no agreement with this, no written agreement with this appraiser that had a 5% cap?
That is our position. That was the testimony at trial. That was the record as we understood it before this appeal enveloped. That being said, I understand that the issue of cap agreements, that's an issue of interest for some courts in Colorado, and to that end, I'm prepared certainly to speak about that. I think the first thing to consider is that our position is that a cap doesn't incentivize inflated appraisals. It's really meant to protect the consumer, particularly in lower value claims, basically to protect the homeowner or the property owner, whether it's single-family home or some business that doesn't have a $3 million claim but maybe has a $20,000 claim. Claims get pushed into appraisal only if there's a significant dollar amount at risk that is going to justify paying an appraiser $20 grand, $50 grand, $100,000. You wouldn't spend that much to replace a $20,000 roof. That's just not going to happen. A cap is meant to protect the consumer in that specific instance. That's our position.
If I may ask, regardless of, and I don't necessarily disagree with what you just said about the purpose, but when you have a cap, does that not give a financial interest in the appraisal to the appraiser?
I think the Court of Appeals addressed that issue. If I remember correctly, they stated cap doesn't indicate bias or partiality unless it actually lowers the appraiser's fee. And so I think if you read into that, the Court of Appeals' position is that that's a fact-based determination for the court to undertake to determine, well, was the appraisal award, or were the figures advanced by a specific appraiser, were they unreasonably inflated, or were they so aggressively advanced that it can only show or reflect bias on behalf of that appraiser?
So does the bias turn on whether there is some possibility at the beginning of the engagement of reaching the cap? See, I'm troubled. But, you can adopt a black line rule, or a court could, that says you have an interest in the cap when you have this contingency fee, or you can have a rule, as you say, it's kind of fact-based. My concern is if we go down the fact-based way, how do we assess that? Because, do you look at the end and see if the cap was actually reached, which doesn't necessarily mean there wasn't an interest? Or do you just say, well, the numbers we were talking about here are so far above this cap, it's never going to come into play, so it's okay. Do you see what I'm saying? I mean, how do we assess that?
a question I have, and I don't mean to evade your question, and I'll answer it in just a second, but a question that I've been pondering as I've been preparing for this argument is, what about the fee agreements, for instance, that of Mr. Burns, where there's no cap at all? He's free to bill as much as he wanted. I can't remember what the record reflected him billing to owners, but if he billed $200,000 or $300,000, I mean, I think it could be argued, on the other hand, that a cap is meant to remind the appraiser, the retained appraiser, that, hey, this isn't a runaway situation where you can bill whatever you want. Mr. Burns certainly had that opportunity. Quite frankly, I don't think it's germane to the issues in this case. But the issue of whether or not a cap in of itself or as a matter of law imparts partiality on any given appraiser, I don't think you can say that as a general rule, and I certainly don't think that you can say that in this case because there wasn't a cap. And there's case law cited in the answer brief of Dakota, pages 29 and 30, the Rios, recently affirmed by Brickell Harbor case, which talks about contingency fee agreements not being indicia or being determinative of whether or not an appraiser is biased as a matter of law. And if that ruling can be extended to contingency fee agreements, a contingent cap agreement is a much smaller issue, in my opinion. So I hope that adequately addresses it. Finally, Dakota Station, on paragraph 69, they talk about there being some causal nexus of impropriety relating to the cap or the award or the billing of the appraiser. Not proven, not even alleged, to my knowledge, in the briefing in this case. It wasn't proven at the Court of Appeals. So the association's position certainly is that the cap wasn't in effect. Even if it was in effect, it wouldn't have imparted partiality on Ms. Haber due to her testimony, due to the evidence submitted at the trial, the contract itself, and the testimony relating to the fees that were billed. Back to...
Before you leave that topic, from an industry standpoint, how common are these contingent cap arrangements?
I don't know. This is the first case of mine, and I will be the first to admit I am not, this is not 100% of my practice area. I am not a first-party property claim attorney. We represent community associations. We're general counsel for Dakota Station 2. I have seen this.
The reason I ask is I'm just wondering if, given your conception of the cap as protecting the policyholder in a low-dollar claim situation, what evidence do you have that that is in fact how these operate?
I don't have any evidence because in this particular case we were talking about 60 roofs, 59 buildings, and a clubhouse rather than a single-family home or a low-value claim. So I don't have any evidence on that. That was the way I viewed it logically when I looked at it, and I think for the court to accept the argument of owners that you have to necessarily read innuendo or nefarious behavior or intent into every contractual provision contained in an appraiser's contract, I think that's going too far. I think a middle ground might be just saying this is a factual determination that's to be decided on a case-by-case basis. It's a factual issue, not to be determined as a matter of law.
Thank you.
In the bulletin B5.26 from DORA, the section that relates to appraisers says in paragraph 2 that the appraiser must disclose to all parties any known facts that a reasonable person would consider likely to affect an appraiser's interest in the amounts determined by the appraisal process, including any contingency arrangement related to payment of the appraiser. I'm wondering if you have a reaction to that. Why do you think that is one of the requirements by DORA or one of the guidelines by DORA?
So that guideline, Justice Moore, is applicable to appraisers and umpires. Essentially, that you need to disclose any known or potentially unknown to the other side material interest, financial interest in the appraisal. Whether or not if you're asking whether or not a contingent cap agreement is something that would need to be disclosed, I don't think that it would for the reasons that we just discussed. I think clearly the bulletin does contemplate that a contingent fee agreement would have to be disclosed. And I'm glad you brought up the bulletin. This iteration of the bulletin, it's interesting that owners relies on this bulletin because we rely on it too. The bulletin has a bright line distinction of the standards that are applicable to appraisers versus umpires. Fair and competent versus neutral. Okay? Neutral is defined by Black's Law Dictionary as taking no side in a dispute. Black's defines fair as free of bias, prejudice, or impartial and disinterested. Okay? There are hairline distinctions, but they're important. I think it's important to also take into account that DORA appreciates the qualitative difference of the umpire versus the appraiser. If I understand owner's argument, and I believe I heard it here today, that all this court has to do is state that impartiality is defined as not favoring one side over the other. That is asking this court to read an undefined term into the policy. We briefed case law on this issue that court is not allowed to do that on behalf of the insurance company. If there's an ambiguity, it's to be construed against owners. And there's a question of whether or not there's ambiguity at all. Impartial, like I said, not defined in the policy. Black's Law defines impartial as unbiased or disinterested. Contrast that with the Court of Appeals definition, where they talk about proceeding with fairness, good faith, and lack of bias. If you can discern a difference between those two standards, I cannot. It appears to me that what owners would have the court believe or adopt is that this Webster's definition, or a common dictionary definition of not favoring one side or the other, should be adopted rather than the Black's Law Dictionary of unbiased or disinterested. So I guess there's the question, is the term impartial, is that ambiguous if you have to resort to a dictionary definition? I don't know. But if the court determines that there's ambiguity, our position is that certainly it shouldn't be construed in favor of owners, and it shouldn't be construed in derogation of the existing DORA bulletin, which has these differences between the umpire and the appraiser.
The problem is, as Magistrate Judge Verhollich pointed out, the definition of umpire uses the word impartial, fair, competent, and impartial. The definition of appraiser just says fair and competent. And that's why I asked Mr. Stevenson the question. So if we want to try to find what impartial means, and looking at the bulletin, it would seem to me we look at the definition of owner, because the contract we have here says impartial.
Okay, so the DORA bulletin, if we're talking about umpires, it talks about neutrality. It talks about being neutral. Okay.
And I suppose I'm looking at the appraiser's bulletin. Maybe they're two different things. But it talks about fair, competent, and impartial. Uses the word impartial. It's bulletin B5.26. I'm not sure if that's the
Correct,
same
Your Honor.
thing. Yeah.
Right.
And so it defines, it says an umpire has to be fair, competent, and impartial. As I understood Judge Verhollich's decision, that's one place we can look at for a definition of impartial. So I think we can't just lift the definition of appraiser from the bulletin because it doesn't use the word impartial.
Right, and I see the language you're talking about. It's in section 3 of the bulletin
Right.
on the first page. I guess the section that I was looking at is on page 2, subsection B, subsection B1. Umpire may not have an existing direct or material relationship with any party to the appraisal and must remain neutral. Okay, so appraisal under A1 above on the same page says an appraiser is considered fair and competent if he or she, and then there's the factors that the DORA considers.
Right. So would you agree that this is the definition here, or the standards under umpire would be a fair definition of impartial?
Yes, we would not disagree with that.
Okay.
And with respect to the umpire, We agree with owners on a few issues. We agree that there should continue to be integrity in the appraisal process. And we agree on the fact that, at least we thought we did, that appraisers are free to advocate within bounds reasonably. And when I say advocate, I mean advance damage assessments or damage opinions to the umpire. If you have 3 umpires who are treated as judges, if you have 3 neutrals, whoever advances damage calculations, you'd never get to a number. And the concern that I have is a concern that I believe Justice Samore might have touched on earlier, which is what is the end game of the filing of this appeal? We have an award that adopts 5 out of 6 damage categories that were advanced or agreed to by Mr. Burns. The only one is roofs. That had a different figure. The judge adopted Ms. Haber's figures for roofs, and the figure was close to $3 million instead of the 2.3, then 2.45 that Burns was at. They want to throw out the entire award, even though Mr. Burns testified, he agreed, he was a repeat customer. Owners was a very important client, those were his words, that he obtained 90% of his business from, and he admitted to Judge Munch in direct questioning from the judge, yes, I advocated, yes, we were arguing about our positions.
And he did say that. He said, I advocated for my position, so did Ms. Haber. Is there a distinction between advocating your position and advocating for your client? That strikes me as, that seems to be what we're fighting about. At least one of the amici here says you have to let them advocate for a client. And I suppose I have some concern about that. So could you address that distinction?
Yes, and I think it's an important one. And I think every appraiser has to be effective, certainly advocate for their position. When does advocating for your position become advocating for the party who has hired you, who is paying you? I don't think that is always discernible in an appraisal or in a court action, even after discovery has happened, as I think perhaps Justice Gabriel, you are struggling with. The record isn't entirely clear on that, and I don't disagree with you on that issue. I don't think that from an equitable or judicial estoppel standpoint that owners can make the argument that appraisers shouldn't be able to advocate for their positions in this case, because the record is crystal clear that Mr. Burns did that. There was testimony that this is not unusual for appraisers, particularly in high-value claims like this, to be advancing their positions to the umpire. And one of the safeguards that we haven't talked about is the umpire itself. And in this particular case was retired Judge Miller from JAMS.
Before you go to that, I wanted to hear the next part. So I'm not sure there's a disagreement that the party can advocate for his or her position. Do you think an appraiser under the impartiality clause can advocate for his or her client? And the client tell the appraiser, you need to argue for $500,000 more.
Well, I'm not sure that happened here.
No, I'm not. It was a hypothetical. Right.
I think under the Black's Law definition, yeah, you could. An appraiser could advocate for the client. If you're using the Webster's definition, as owners would have the court adopt, then I don't think that you could. So again, we're back to hairline distinctions, but I guess what I'm struggling with as the advocate for Dakota Station in this proceeding is that it almost, so many of these issues are academic because they didn't occur in this case. There was advocacy. There's no doubt about it. Mr. Burns admitted it. There was submissions to the umpire. There were no allegations by owners of any impropriety in the appraisal process. Once the award entered, they paid the award. Significantly, the policy allowed them to deny the claim even after the appraisal award was entered. So there's a lot of, I don't want to use the word, but there was a lot of hyperbole in some of the briefing on owner's side and from the amicus briefs saying, oh, this is going to result in widespread fraud and this and that. We simply disagree because there are safeguards built into the process already. One is the umpire. An umpire, a true neutral, like Judge Miller in this case, is not going to accept unreasonable or fraudulent damage valuations, and there's certainly no proof that that happened here. And second of all, in this particular policy, owners had the option to deny the claim after the appraisal award. That gives them a distinct advantage, as even the dissent in Dakota recognized. Owners has many $billion in reserve. My client is a nonprofit corporation. My client probably will never have an appraisal proceeding that they will engage in perhaps in the next 100 years. Owners probably has 100 pending right now. So owners already has a built-in advantage in this proceeding. They had the right to deny the claim even after the award came out. Dakota Station didn't share that right. If the appraisal award came back at $50,000, Dakota Station couldn't have said, well, we disagree, we just want a do-over. We'd end up in court. We'd end up in court where we are here today. And I think if the Supreme Court were to reverse the Court of Appeals and adopt this bright line rule that owners is advocating for, that appraisers have to be held to the standard of a judge, of a neutral, all you're doing is giving a green light to insurers, essentially to file a lawsuit challenging the partiality of a policyholder's appraiser if they don't agree with the award.
I have a little concern with the majority standard here, and maybe you can help me, and I think it's a position you're advocating for. What is it to be impartial and to be unbiased, but at the same time be able to advocate for one side? Do you see my concern? And then isn't that going to lead to disputes in the future? I mean, can you see how that would be open to all kinds of disagreement? That sounds to me like impartial sort of, or impartial light, or semi-impartial. And I don't know what that means.
I believe that it means that you have to act in good faith. Your figures have to be reasonable. They can't be inflated. They can't be artificially conservative. If it's an appraiser for the insurer side we're talking about, the appraisers have to not, at least now, they can't communicate with the party that hired them. They're not to have ex parte communications with the umpire. And that last point is one that I think is important to distinguish these cases, the two cases that are relied upon by owners so heavily. There was never any ex parte communications between the parties. If you read the language in the Providence case, there is probably 5 times that we've seen from owners where they quote, "Appraisers are not referees, but their duty of impartiality is the same." They would put a period there and say, this is binding precedent on you, this 100-year case, never been cited, but in any case, before the dissent in Dakota, they would say this is the standard. Appraisers and umpires are judges, that's it. But if you keep reading the rest of the sentence, it says, we do not think that it, i.e. impartiality, can be attained by awards, umpire awards, without either the presence of all or notice to each. This case was decided in the context of improper notice, of improper communications between the appraisal panel. That was not the case here. Providence was also a case involving arbitration. The appraisers were actually arbiters. That was also the case with Knopfsinger, a case from 1936. Knopfsinger, at page 156 of that case, actually talks about the different standards and the different qualities applicable to judges versus arbitrators. So that case inherently in of itself, again, talks about qualitative differences between not an arbitrator because we're in appraisal, but appraisers versus an umpire. So these cases, I understand how reading the first part of that sentence in isolation, which really is dictum, that's the association's position anyway, how that might be attractive for owners to try to argue, because what they're trying to do is set up such an impossibly high standard here that if they ever have the notion that, you know what, we don't want to pay this award, or as I think happened in our case in Dakota Station, there is a pending corollary federal court case brought for unreasonable delay and unfair claims practices that has been stayed. This challenge was only brought after that lawsuit was filed. So I think what you have here is, if the Supreme Court is to reverse the Court of Appeals, essentially what you've given carriers, not to bash on carriers, I have insurance, you know, some play fair, and I'm sure owners does, and in other cases we strongly disagree with their conduct in this case, because what we've seen is a lawsuit brought challenging the partiality only after they were sued for bad faith. And if the standard for owners to say this person was impartial, if the standard goes from being an appraiser, which is here, to being a judge, that makes it that much easier for them to sue in the future. And that just gives them another quiver, another arrow for them against the policyholder. And the odds are already stacked against the policyholder. There's just no other way to look at it. So for those reasons, it's difficult for Dakota Station and for me as their counsel to really try to discern what the end game is by this appeal. Because it seems to me that owners is fine throwing the baby out with the bathwater. They're fine with blowing up this appraisal provision, which is in so many insurance policies, just despite Dakota Station in this case, because Dakota Station called them out on their claim. I'm not sure if it was in the briefing, but the initial loss estimate here by owners, independent adjusters, what they call them, assent claims, was for $8,900. Dakota Station asked them to come back over months. A year later, they came back. They said, you know what, our number stands. Oh, by the way, you're under the deductible. We're not going to pay you anything, but you can go to appraisal if you want. They encouraged, or they forced, the association to go into appraisal here. And once we did, we had Mr. Burns appointed, Ms. Haber appointed. They were on the roofs for, I understand, for weeks, if not months. They were able to meet some middle ground, but they weren't able to agree on everything. And the number went from 8,000 to 2.3 to 2.45. I don't think that number can really be ignored by the court. The Court of Appeals certainly didn't ignore it, and we would certainly suggest to the Supreme Court that that number is evidence that independently, owners' own appraisal, their own agent determined that there was significant multi-million-dollar damage to this property.
Mr. Hunt?
Yes.
I think your time's run out.
Thank you very much.
Mr. Stevenson, before you even start,
Yes.
can I ask you?
Yes.
I think it sounds to me like you have more familiarity with this industry. Are contingent fee cap agreements common in this industry?
I would say among a certain set, it is more common than others. I don't believe it's standard for the average appraisal. I think where you see it more often is in very large, very large appraisals with sophisticated public adjusters and lawyers involved. It's more common there. It's not common in Colorado, certainly not anymore. I think when some of these cases first started out, it was more common, and then several judicial decisions pointed out the problems with this, and people stopped using them. I can tell you where they came from. They emanated from Florida. Florida is an extreme aberration in the United States in that it actually allows appraisers to get a piece of the appraisal award that they give. And so a lot of the early people who adopted this were from Florida, and that was called out by several federal judges, and it basically disappeared. And now, because of Dakota Station, it could be making a comeback. So the short answer to your question is, among a certain set, at the higher end of these appraisals in certain parts of the country, it's more common. I do not believe it's part of the average appraisal in Colorado, and hasn't been for decades. It's something that's been introduced recently from other jurisdictions. to the best of my knowledge. Justice Sommore, you are correct. The Court of Appeals opinion is internally inconsistent. It is not possible to both favor one side and be unbiased. If you look at what the word unbiased means, it means not to favor one side. The Court of Appeals opinion is creating enormous confusion throughout Colorado in all the cases where this is being addressed. The rest of the sentence that we quote so much of in Providence, I don't run away from it at all. Here's the full sentence. Appraisers are not referees, but their duty of impartiality is the same. And we do not think that, which he just said means impartiality, can be attained by awards without either the presence of all or notice to each. So this court made clear in that sentence that the reason that notice mattered in Providence was to attain impartiality, the same impartiality that an arbitrator has. So I don't run away from the rest of that sentence. That supports our argument. The contingent caps are, their argument is that it protects the consumer. Two responses. First, the intended purpose of the drafter is irrelevant. What is relevant is the incentive it gives to the person who's doing the work. So it doesn't matter what the intended purpose of the drafter is. But in any event, I bill by the hour. When my clients want to be protected, they don't tie my compensation to an award. They say, let's talk about a flat fee. There are tried and true methods for protecting consumers that don't involve tying the outcome to the person's compensation. So, and you don't have to review that finding under a deferential standard review. That you can review that de novo because it's a written legal instrument. The 5 out of the 6 categories, Mark Burns and the umpire agreed. But over 85% of the award is one category. So I'll trade you. I'm happy to trade you. So that is a red herring. $2.55 million of it is the roofs out of a $2.9 million award. Mark Burns did not advocate for owner's position. He came up much higher than owners. I see I've run out of time, and I thank you, Your Honors.
Thank you very much. We appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess.